I think so. The starting point for that is in many legal jurisdictions, particularly across Europe, the appointment of prosecutors is done by a council, a quasi-judicial council, who will consider applicants, interview them, and then appoint. That's not the way it works in England and Wales. I think it's a feature of the very different non-common law system that operates in most European jurisdictions, where there is a dual role of the prosecutor. Prosecutor is also investigator. And one thinks of examining magistrates in France, for example, where there's an investigatory power alongside a prosecutorial power. We're unburdened with that. We're prosecutors only. So we appoint our own staff, and it is a straightforward, open application system where we appoint the best from amongst the legal ranks to become prosecutors. But as your question correctly suggests, when it comes to the delivery of the hundreds of thousands of cases that we prosecute each year, we do not have the in-house resource to do that alone. The current split in advocacy terms is that 20% of casework is delivered through in-house advocacy, and that includes a cadre of several hundred Crown advocates, many barristers, but also some solicitors with rights of audience, whom we employ full-time and we deploy to the courts to prosecute our cases. But that's 20%. The other 80% is delivered by the external independent bar on a panel system. So as you say, it's not permanent employment. Application, which I think is fairly rigorous, to a series of panels. And we have general panels from entry level, panel 1, up to highest category, panel 4. And then there are specific panels, for example, for rape and serious sexual offences, for fraud offences, which experienced advocates can apply to join. So it's that hybrid relationship that allows us to drive all of the nationwide casework. I think if you look over the last 20 years, there have been directors who have been more aggressive and less aggressive about that. In the recent past, there are those who've said we should increase our in-house capacity to have more full-time employed prosecutors. And there are others like me who've maintained the status quo, although it's all subject to backlog and the flow of cases, which is very difficult at the moment. The only other thing I would add, though, is that I don't want us to overemphasize the advocacy of our cases. The division we have between in-house Crown advocates and external barristers is about advocacy. But when it comes to the administration of cases and the all-important decision to charge under delegated authority from the DPP to an individual prosecutor because of the Prosecution of Offences Act 1985, that is a duty that is undertaken solely by fully employed in-house prosecutors. So it will always be an employee of the Crown Prosecution Service who determines whether a case is going to be charged. And I think that is important constitutionally, and from the point of view of superintendents, and from the point of view of sanction in the event that that is not done well.